morning, everybody. My name is Rose Morales, and I am very happy to be, I'm an antitrust counsel at Crowell & Moring, based here in New York, in the Antitrust Group. I am very happy to be here to moderate today's panel. Today, we're going to talk about a critical and evolving frontier in competition policy. We're going to talk about how antitrust law is being used and tested as a tool to address power, mobility, and control in labor markets. As part of that discussion, we will touch on the theories of harm at play, how evidence is assessed in labor market cases, and recent enforcement trends in this space, particularly as they relate to non-competes, no-poach agreements, and algorithmic management tools. Now, to guide us through this discussion, we have an exceptional panel of experts, starting with Suresh Naidu, who's a professor of economics at Columbia University and co-director of the Columbia Center on Political Economy. He's a widely recognized scholar. His interdisciplinary research examines labor market power, workplace mobility, and the role of economic institutions across historical and modern settings. His influential work spans monopsony, labor unions, guest worker migration, algorithmic wage setting, and the economics of American slavery. Very interesting stuff, offering a rigorous framework for understanding how institutional constraints and market structure shape labor outcomes over time. Next, we have Ioana Marinescu, who's an associate professor at the University of Pennsylvania's School of Social Policy and Practice, with appointments in economics at the Wharton School and faculty research fellow at the National Bureau of Economic Research. She's widely regarded for her scholarship on labor market competition and monopsony power, with research examining how employer concentration, technology, and market design affect wages and employment. Her recent service as principal economist at the U.S. Department of Justice Antitrust Division contributed to the incorporation of labor market analysis into the 2023 merger guidelines, reflecting the growing integration of economic research and antitrust policy. She also advises policymakers and companies, including as member of Anthropic's Economic Advisory Council. Next, we have Evan Starr, who is professor of management and organization at the University of Maryland's Robert Smith School of Business. He's well known for his empirical research on labor market competition and employee mobility, including the use and effects of non-compete and non-disclosure agreements. His work also examines algorithmic management and employer practices affecting workforce dynamics. In addition to his academic contributions, Evan has frequently advised policymakers and testified before Congress, the FTC, and state legislatures, placing his research at the center of ongoing debates about labor regulation and innovation. And last but not least, we have Jonathan Gurian, professor of education and social policy at Northwestern University and a faculty fellow at the Institute for Policy Research. His research applies rigorous quantitative methods to questions at the intersection of education, labor markets, and inequality, including labor market discrimination, human capital formation, and economic mobility. As co-founder and co-director of the Education Lab, and with affiliations across economics and management, John's work contributes to policy-relevant analysis of how institutional design and technology influence educational and employment outcomes. So that was a mouthful. Very impressive panelists. Please join me in a warm welcome for our speakers. That was very impressive. Thank you for joining us. So I want to start the stage, to set the stage by grounding us in the legal framework, because as you can tell, we have a bunch of economists on this panel. Yeah. So we're going to talk about how antitrust law approaches labor markets, how competitive harm is assessed in this context, and what courts and enforcers mean when they refer to market power in labor markets, as opposed to what the economists are going to say. So as a threshold matter, antitrust law recognizes workers as sellers of labor and employers as buyers of that labor. There is no categorical exemption for labor market restraints, and courts have long acknowledged that the antitrust laws may apply to restraints affecting input markets like labor. Two Supreme Court precedents establish that labor is subject to antitrust analysis. The Mandeville Island Farms case from 1948, where the Supreme Court confirmed that buyer-side restraints in input markets fall within the scope of antitrust. And more recently, in the 2021 Supreme Court case NCAA v. Alston, where the court reaffirmed that restraints affecting compensation are subject to ordinary antitrust scrutiny. So once we establish that it's within the scope of antitrust laws, the inquiry turns to a familiar antitrust question: whether competition has been restrained in a legally meaningful way. As in any antitrust case, the inquiry depends on defining the relevant market, which provides the analytical framework for assessing market power and competitive effects. Now, from a legal standpoint, and I'm going to stop talking in a few minutes, labor markets are generally defined by substitutability from the worker's point of view, whether workers with particular skills can reasonably move among employers, accounting for factors such as geography, credentials, and other factors. Courts approach that inquiry using established market definition principles, including by looking at indicia such as functional interchangeability, practical alternatives, and industry recognition associated with what are called the brown shoe factors, while accounting for the distinct characteristics of those particular labor markets. Labor markets are evaluated under familiar doctrinal approaches, per se, and rule of reason. Certain categories of conduct, such as naked wage fixing or no-poach agreements, have been treated as per se unlawful, where liability turns on the existence of an agreement, the proof of an agreement itself, and not on market effects. Other employment-related restraints, such as non-competes, non-solicitation provisions, and information sharing practices, all of which we will cover today, are generally evaluated under the rule of reason. And there, plaintiffs bear the burden of establishing antitrust injury, typically by showing harm to competition for workers, such as reduced mobility or suppressed wages in a properly defined labor market. Federal enforcement efforts in recent years involving labor markets have generally increased across administrations and with mixed results. Federal agencies continue to investigate wage fixing, no-poach agreements, and related practices such as non-compete, but there has been skepticism about adopting broad regulatory tools, as we've seen in recent years with the FTC's attempted nationwide non-compete ban under the Biden administration, which was enjoined and later abandoned on appeal by the new Trump administration FTC, which has resorted to a case-by-case approach for labor market enforcement. So, taken together, that's the legal framework. Those are the boundaries. Questions that ultimately must be answered are market definition, market power, competitive effects, and causation. So with that legal framework in mind, we still don't have the empirical tools needed to answer them, which is why we have these folks on this panel, and why we're going to turn to Suresh first to tell us the basics. So Suresh, how do economists define a labor market for antitrust purposes?
Got it. So thanks for having me on. So I'll start with the thing that's like not useful for lawyers, which is just like, think of the hypothetical experiment where like your employer cuts your wage by like 5%. What's your probability of leaving? And so we try to estimate that number in many different ways across many different contexts, and we generally find that it's pretty low. And just think about it, like how much would your employer have to cut your wage for you to really be able to walk out the door? And it's generally the case that most people aren't sitting on another offer, that it would be hard for them to find another job as good as the job that they have. And so that, and all the factors you mentioned earlier about geography, skills, enter into that. I will also say, though, one of the biggest parts of it is what we call amenities and idiosyncratic, like basically think of commute time. Do you get along with your coworkers? Is it close to your kids' childcare? Like all of these other factors about a job make it that it's actually the space of jobs is very thin. And so it's actually pretty hard to switch. And even if it looks like there's many employers in the market, they're actually not perfectly substitutable for each other. And so you're kind of stuck. And so that's kind of like how we see it from the point of view of the presence of market power. But the reason that that's not informative for lawyers is because, as was said in the earlier crackling panel, the presence of market power itself is not an anti-competitive harm. And so, I came into monopsony by studying minimum wages and other institutions where there's not necessarily an anti-competitive harm. It's just monopsony is just everywhere. And the cases that become interesting are where it comes up because it's the result of some anti-competitive practice. There's some merger that's kind of happening that's pushing the level of monopsony power to some unreasonable level. Or there's naked open wage fixing. And so those are the kinds of labor market power that draw the scrutiny of antitrust authorities. And so we've been, and I think other people on this panel know a lot about this, have been looking for the legal sort of porting the concepts from the product market to the labor market, like things like hypothetical monopolist tests and concentration ratios, and what constitutes an unfair competitive practice. These are concepts that we're kind of bringing in from the existing product market context and trying to find analogs in the labor market context. And I think some of those are going to work, and some of them might not work, and we're kind of at the early stages of this.
Can you give us a finer point on how labor markets differ in meaningful ways from product markets? That's what we're used to seeing and analyzing. And specifically when we're thinking about competition and market power.
Yeah, so I think there's some products, as we've moved to a service sector economy, actually the boundary between, product markets look a lot more like labor markets, and healthcare, health insurance, these things are, the distance matters, the exact idiosyncratic characteristics of the provider matters. And so, you can't wait. So manufacturing economies, you could it's a durable good, so you can wait a little bit. And, so I think there's a lot of ways in which the service nature of the current product market makes it look a lot closer to the labor market. I will say there's many differences between the labor and product markets. One is that you're in this kind of long-term relationship with your employer in a way that not so many products have that kind of nature. And so just looking at a static index doesn't necessarily capture the duration of a relationship with a given employer. And the second thing, and I think a really fundamental thing, is there's not really an analog for the idea of unemployment in the product market. A lot of workers, they're worried about being fired, and that finding another job, and that you're unemployed. Where there's employers out there, but they don't want to hire you, and so that doesn't have a natural analog in the product market because everybody wants to sell as much at their going price. But there's so I think lots of parts of economics have thought really hard about why there is unemployment and where does it come from, and that is something that's not sort of naturally mapped into from the product market side of things.
That's an interesting point regarding unemployment. So we were talking about that the substitutability comes from a perspective of a worker. Now, if a worker, let's say, just doesn't want to get a job, what does that do to the calculus, the analysis regarding market power and the definition of that labor market?
So I think it's one thing that we find when we try to estimate the degree of labor market power. It is employers have a lot more labor market power when there's a lot of unemployment. And so the business cycle just kind of does some work in increasing labor market power, and that doesn't show up as a concentration ratio necessarily, or as as a natural metric of market power. And it's just the case that when workers don't have a lot of alternatives, employers can set wages lower than they otherwise would. And so I think that's something that there's not a grammar for it. It's not something the antitrust it's not legally set up to handle that kind of labor market power. It's not clear that's not a result of any anti-competitive practice, but I think it's actually important for the exercise of market power on the ground. So I think some papers have even found, that the take-up of non-competes was really high during the Great Recession because people were kind of desperate, and so they signed non-competes when in a tight labor market they wouldn't.
Did you want? I see you're shaking your head.
Oh no, I was just remembering the stories of the hospitals that were requiring doctors to sign non-competes exactly at this time because they had more leverage.
So I want to talk a little bit. I think we've been assuming that we're not talking about labor unions. We're not talking about unionized workers. So can you tell us how does monopsony differ, monopsony power differ from what we typically think of as collective power exercised by labor unions?
Yeah, well, Clayton Act exempts unions from antitrust regulation, so that the collective exercise of workers, kind of like saying, okay, you have to hire all of us or none of us at a given wage, that's like protected. It's I think one of the kind of interesting things about unions, and there's some very interesting research on this in Europe because there's not really that many unions in the U.S. anymore, but that there've been not only are they effective at like raising wages, they're also really effective at specifically targeting monopsony power in kind of the same way antitrust is, because you're able to toggle your demand to the amount of monopsony power the employer has in a way that like a minimum wage or something that's like a floor can't exactly be like, oh, actually, you've got a lot of rents, we're going to ask for a lot of them. And unions kind of can, by bargaining, can kind of are pretty effective countervailing power to labor market monopsony. There's an interesting, I think I might know more about this like Kroger Albertsons kind of case, where one of the definition of the labor market taken in enjoining the merger was that there was like the unionized grocery workers were the definition of the labor market, and that was, and it's because like when one of them had a strike, like in 15 years before, the other one agreed to not hire any of the striking workers. And because they were like had this kind of agreement to not hire the striking workers from each other during a strike, that then was used as an argument for the injunction.
I think in this case, the unionized nature of the job can be seen as a more general example of a job characteristic that workers care about. So it's at a high level of abstraction, similar to the distance. This job is special because it's a unionized job, and some workers really want to be in a unionized job. And therefore, a non-unionized job, even if otherwise similar, is not the same as a unionized job. I'm a union worker, hypothetically, I want a union job. So therefore, my closest substitutes would be another union job. And those non-union jobs, even if otherwise similar, are not a good substitute. So that, we're getting to market definition, that would be the contention, that non-unionized jobs are not a good substitute for a unionized job. And that's sort of where the analysis goes a lot of the time in terms of looking at the characteristics of this job and what makes this job unique, not completely unique, but distinct, let's put it this way, from the point of view of the worker, and different from other jobs that they might be able to substitute to. And I also want to talk about the unemployment side, which I think is really interesting. It's true that we don't necessarily see this a lot in other markets, but it's not completely true. And I think often we don't think enough about B2B markets, where both they tend to be long-term relationships, and they also can be quasi-phenomenon like unemployment. When you're a small business with one major client, that's the client, and they fire you, you're in trouble. You're going to have to, find something else, and that can take some search and figuring out who else might want to take you and so on. So, there's certainly some analogies, and I think I really encourage people in particular with labor, if you're working in any cases and practices that involve B2B markets, I think those are often quite similar in many respects. And I think we can learn a lot from the practice in those markets.
So, John, I see you kind of shaking your head.
I wasn't. No, definitely not shaking my head.
Definitely not shaking your head.
I have no mafia analogies.
But I do want to hear from you, John. I want to ask you how these the institutional features such as education pipelines, credentialing requirements, or geographic constraints shape how long employer power can persist in labor markets.
Sure. So, Suresh made the great point that in sort of the study or the analysis of market power in labor markets, they're taking a lot of the tools that came from antitrust economics and product markets, and a lot of those do carry over. I mean, the same idea of thinking about a market based on the substitutability of products from the perspective of consumers sort of carries over to the idea of thinking about a labor market in the sense of what jobs you think of are substitutes from the perspective of which one you'd be willing to do, which feeds into the answer to Suresh's question about like if your employer lowered your wage, would you be willing to leave? Part of that is depending on what jobs do you think you could get if you were to go search around. As a labor economist and somebody who studies education, I think one of the key frameworks that I think of for thinking about labor markets is a study of human capital. And so that both fits into this framework, but also has some points to some interesting ways that labor markets are a little different from product markets. So one is that if you think about the definition of a market, of a labor market, it often is shaped very differently than the product markets of the employer that the workers work at. So maybe you can think of companies that operate in a single product market, but you can't think of a company that hires in only one labor market, because all the different workers that they hire have different types of skill, different levels of education, they're doing different jobs, and so their alternative jobs are going to be very different. And so employers are often hiring in lots of different labor markets, and the other is that the labor markets that they're hiring in often span boundaries across industries and even across occupations. So people, over the course of their career, often switch industries, sometimes they'll switch occupations. And so thinking about that when you're thinking about defining what the market is really important. Also because many of the things the practices that are challenged from an antitrust perspective, often those happen within an industry. So there are agreements maybe between competitors in a product market, but the workers that they affect, often the labor market that they operate in, can go across industries. And the other important thing about human capital is that human capital and skills that sort of determine what jobs you're able to do and how valuable you are to an employer, those happen as the result of investments. Some investments happen through education, some investments happen over time through training or just on the job learning. And so that's the other thing that's important to think about in this long-term relationship between employers and workers is how what either the challenge conduct or the remedies, how they affect the incentive to invest in skills, which changes the human capital that workers have over long periods of time is really important to think about.
So what I'm hearing also is that the boundaries of the market definition and whether there's market power will vary depending on the type of worker, right?
For sure.
So for example, lower wage workers might operate in a different geographic market than higher skilled workers. Is that right?
Absolutely, and even within the same firm, the same employer might have some workers that are whose labor market is very national, right? They're thinking about, so think about a hospital, in an academic hospital. Maybe many of the doctors, their labor market might be very national. Like, so if you're a doctor working at a hospital associated with Columbia, the job offers you get might be from a hospital in Texas or Los Angeles. Whereas many other people working at the hospital, their labor market is very, very local and geographically limited. And so that's going to, so even within the same employer, there's variation in the size of the market, the scope of the market, the geographic reach of the market, and all sorts of things.
Yes, go ahead.
And so I just wanted to add here for everybody that actually in the 2023 merger guidelines, there is section 4.3.d.8, which describes, how you define labor markets. And some of the things that are talked about there include things like your occupation, your location, as well as non-wage amenities. Like we talked about an example, it's not in the guidelines, it was the union, but there could be other aspects of the job. So, examples that are, used there include things like this person, your employer, or the person you're working for pays on time. That's really important.
Yeah.
To workers. And that again, I think can occur in other contexts that are B2B, and we also have contractors. So that's another interesting element, which is that with labor markets, there's also different contractual forms. So you could also have these issues occur with not employees, legally speaking, but contractors who are working, for these companies as independent contractors. But the analysis of the labor market definition is very similar. It's just that the facts could be a little bit different. You have to look at this specific type of job, and what matters to these people who are doing these jobs in terms of back to what other jobs are substitutes.
Right. Yes. Good.
Can I just raise one point, which is I want to make sure we don't miss the historical context to what Suresh said, because I think that if you go back even just 15 years, you'll find many people thinking that labor markets are mostly competitive. And I think the renaissance that's happened in the last 15 years, or maybe if I go back a little bit longer, but is that as Suresh said, we've sort of learned that labor markets are actually not that competitive, and that the default, I think now, at least among the leading scholars, is that every firm has some degree of labor market power. And so, there's always a question in antitrust, well, a company couldn't suppress compensation unless the company had some market power. And I think that, when we talk about how do you define a labor market, these are really important issues. But I think that the default has sort of shifted from labor markets are competitive to every firm actually has some degree of labor market power. And it's going to vary across industries, and there's going to be institutional features that matter. But just that default has changed. And I still see people saying sometimes, well, a company hired workers from all over the place, this industry, this state, that state. Therefore, their market is competitive. And I think that it's important to realize that the economic research suggests that they're hired all over the place. Maybe there's lots of places they hire from, but that doesn't mean that the labor market is perfectly competitive.
Yeah, let me add one thing to that I like to. So because I started studying this in the low-wage labor market, and people would always make this case that oh, McDonald's, how can they have any market power? People are just walking in and out of a McDonald's all the time and finding other employment, and so the turnover is super high. How could there be any monopsony power in that kind of labor market? And sort of one of the things we've sort of seen over time in these papers is that you can have lots of turnover, but that turnover is not sensitive to the wage. And what's important is that the turnover falls a lot when you pay a little bit of a higher wage, and that's what you don't see. So the turnover is there, and it's very high, but it's not sensitive to the wages being paid. And so that's suggesting that, again, those firms have a fair amount of monopsony power despite having high turnover, because that turnover is not very sensitive to the wages that they're paying.
Have we seen any change? Has there been any impact by the increase in minimum wage?
Yeah, so minimum wages, I think, I was worked on this, and yeah, I think definitely are probably that's why antitrust isn't a great tool for the McDonald's monopsony, except for the no franchise agreement stuff. But the minimum wage is just kind of puts a floor on the ability of employers to exercise the monopsony power they have.
Suresh, can you give the example of the gig work paper that you have? Because that's the most extreme example I can.
Yeah. So that's it's actually related to the last panel also. So we did this paper where we estimated how many people here know what Amazon Mechanical Turk is? Some of you. So it was like an online platform and still exists. It's just been taken over by bots, so it's kind of a little bit useless. But it was a place where data labeling would happen, and it happens, and so you lots and lots of scientists and firms kind of post tasks for workers to just tag this image, et cetera. And so we did so it was funny because computer scientists had sort of run experiments on Amazon Turk for data labeling things. And we were like, oh, you could, and so for some of them, they had randomized the wage to just see what happens. And we had sort of noticed, oh, that's actually estimating the degree of market power